Welcome, everybody. I'm Noeline Hammond-Jones. I'm the Deputy Head of Careers at Lancaster University Management School, and I'm also the co-chair of the International Task Group for AgCAS. Today, I'm joined by Gemma and Arsalan from JMW, who are going to share with you a visa session to help you understand the recent changes to visas, but also look at the potential discrimination as well in job adverts, etc. So thank you for coming today. This session is being recorded and we will share the recording afterwards along with the slides. And also this will be on the Lancaster University Management School Careers YouTube page as well. So thank you again for coming, and I'll pass over to Gemma and Arsalan.
Thanks so much, Noeline. Hi, everyone. So like Noeline said, my name's Gemma and I'm an immigration partner from JMW. So I'll just start with a little overview of what we'll be considering today in this session, and then I'll do a little bit of an introduction into myself and Arsalan so you understand a little bit more about ourselves. So today's session is dedicated to employing international students and graduates in the UK. So we're going to start off with the immigration side of things, which will be presented by myself. We will be looking at student work restrictions, how you can employ those who have completed studies in the UK via the graduate route, and then we'll delve into the skilled worker route. So we'll be looking at who you can sponsor, that dreaded question about how much salary you have to pay, and then kind of how you can go about sponsoring those workers. My colleague Arsalan will then look into how you can avoid discrimination when you're advertising for graduate roles, and we will finish with a Q&A at the end. So I don't know if we'll be inundated with questions, but we'll see how we get on. I guess you can put questions in the chat and we can work our way through that, and also happy kind of if you want to put your hand up and ask a question. That way, Arsalan and I will be happy to help. So a little bit of an introduction. So JMW is an award-winning full-service law firm. There's a link to our About Us page on this slide. From there, you can learn about kind of the awards that we've got in the past and the different departments that we have in terms of how we can help your businesses going forward. Myself is Gemma Tracy, and I'm a partner here. I am a specialist UK inbound immigration solicitor, and I've worked in this area for more than 10 years now. I help businesses and individuals navigate the UK's immigration system, largely through kind of sponsored work and things like that, but can also assist with private immigration as well, for those that might be joining family members in the UK, or kind of the good old days when we were a member of the EU. Arsalan, do you want to do your own intro?
Thank you, Gemma. So my name is Arsalan Rashid. I am a solicitor here at JMW. I specialise in both employment and immigration, and I work across a full breadth of contentious and non-contentious law. So that's advising employers and employees on matters such as discrimination and anything sort of wider than that also.
Perfect. So we'll start with student work restrictions. It's quite useful kind of at the student stage when you've got a sponsored student to understand that they can work alongside their studies. Most students can, I should have said. Those who are studying at degree level or above, which is largely the applicants that you'll be presented with, particularly those who have graduated from Lancaster, can work up to 20 hours per week during term time and then full time during vacation, which includes the period before that the course starts. It's always useful as employers to retain documents relating to this, so to confirm that the students can work. So you need to look into kind of the term time dates, so kind of liaise with the university in order to get them from the university. If the individual has completed their course, they can work full time. It's considered outside of term time, but you need confirmation that that student can work. And when on a work placement that is as part of a student course, students can also undertake employment. Work placements is quite an interesting one, actually. It's not used by many employers in the UK, but it means that certain students can undertake a work placement that's assessed as part of their course. and they can work full-time during that period. So it's always a route to look at if you're kind of, you may already have a student working for you part-time kind of alongside their studies. Or recently I had someone who potentially was promoted to a manager so that they could do the work placement. The work placement that you're offering doesn't necessarily need to be kind of in the main kind of subject of the course. So by way of example, I had a student a couple of weeks ago who was studying a management engineering degree, and she was able to do a work placement as a manager in a retail setting, and the university were happy with that, and it meant that the student could work full-time during that work placement. Obviously, outside of that work placement, they would be subject to the kind of the part-time hours during term time, full-time during vacation. One important rule for students that are working alongside their student visa is that they cannot fill full-time permanent vacancies. There are, with everything related to immigration, potentially some exceptions to this, but the general rule is that a student cannot fill a full-time kind of or a permanent vacancy. So always make sure that any contracts offered to them are on a temporary basis. The next route for a student that they'd be considering is the graduate route, and this is an unsponsored visa route. It's been subject to a lot of press recently because it was assessed by the Migration Advisory Service, who essentially looked into kind of whether it was being abused, but the MAC have confirmed that it's not being abused. It's really important to the UK, to universities, to students wanting to come to the UK, and MAC confirmed that it should stay. And we've recently had confirmation from the government that it will be staying. Of course, there are kind of articles online indicating that the government may be reconsidering this. And with the general election coming up, we don't know exactly what's going to happen. But for now, the graduate route is staying. The route is for international students who have completed a bachelor's or postgraduate degree in the UK, but it also covers other courses too. So the LPC, for example, is a course that is covered by the graduate route. Ordinarily, those that have completed a course in the UK as a student would get 2 years leave to remain, potentially 3 years if they've been awarded a PhD, and during this 2 or 3 year period, they're free to work wherever they please. They can do self-employment, voluntary work. They can't work as a professional sports person, which is something that's kind of a restriction carried across many categories of the immigration rules, but it gives the student freedom in terms of where they work. You know, they're not tied down to one employer. So it is quite useful kind of from that point of view in terms of getting that student into work once they've completed their studies. So even if a student gets a graduate visa, they are really looking at getting sponsorship under the skilled worker route. This is a sponsored route, so a student needs a sponsor to be able to benefit from the skilled worker route. And it is a route that leads to settlement. So after a skilled worker has held a skilled worker visa for 5 years, they'd then be looking at kind of getting settlement or indefinite leave to remain in the UK. So it's a very desirable immigration route for a student. Under this route, kind of those that hold a sponsor license, so these approved sponsors in the UK, can look to recruit not just necessarily student, but kind of any kind of international migrant in the UK into an eligible skilled occupation. So they can't do any work. It has to be a role that is suitable for sponsorship. And it's the immigration rules that essentially confirm what roles are suitable for sponsorship. So we have something that's called Appendix Skilled Occupations, which if you open is a very, very long list of jobs. There's various different tables in there. For new sponsorships, we're probably going to be looking at table 1, but there are other tables in there. So table 2 would cover those who were sponsored prior to the 4th of April 2024 as a skilled worker. And then we also have tables dedicated to those who are doing kind of health education roles in the UK that are recognised. Appendix Immigration Salary List is still an option as well. This is a new category. It replaced what was called the shortage occupation list, and the government have essentially said that this isn't necessarily a list of shortage occupations, but it's a list of those roles where a lower salary can be paid. So it's jobs where the government think that it's acceptable for a lower salary to be paid. It has been significantly reduced. So there used to be quite a lot of engineering roles on the shortage occupation list. Quite a lot of those have been removed now. But you'll see kind of in the coming slides that it's always worthwhile considering whether the role that you're wanting to sponsor the individual to do is on that immigration salary list. As with most immigration categories, there's always a subjective element, and that's something just to bear in mind kind of when you're advising students, when you're looking at sponsoring them. The Home Office are always going to look at whether the role is genuine, so whether your business is a business that can genuinely offer this skilled role, and whether the worker can genuinely undertake the role. So they're looking at kind of whether you've done your due diligence and your recruitment exercises to make sure that this is the ideal candidate, and you haven't essentially just created this role for immigration purposes. So it's just always something to bear in mind kind of when you're considering the roles going forward. Perfect. So because the skilled worker route is so desirable, it's what many students want. Even if they do get that initial kind of graduate visa, they are looking at getting sponsorship on this route. So I'm going to delve into the requirements a little bit for you, and hopefully you'll learn that it's not as scary as what it sounds. There are a lot of requirements. They're quite strict in terms of salaries and things like that. But you know, if you get the right support, it's a kind of a situation we can navigate through. So the main kind of requirements that a skilled worker would need to comply with is that they need something that's called a certificate of sponsorship, or a COS, from an employer in the UK that holds a sponsor license. So this is issued via something that's called the sponsor management system, which you'd be able to gain access to once the sponsor license is held. There are quite a lot of requirements in terms of kind of the information on the certificate of sponsorship and when you can assign them. But the main things really that we've got this genuine role, it's acceptable for sponsorship, and the minimum salary is paid, which I'll be coming to shortly. Another requirement is the English language requirement. So the student will have to demonstrate that they have sufficient knowledge of the English language to level B1. Most of the ones that you're going to be dealing with are international graduates, bearing in mind this is a visa session operated by Lancaster University. So they're already going to have completed a degree or kind of some form of qualification in the UK, which will likely be able to rely on for the purposes of the English language requirement. There is also a financial requirement, but if they've already been in the UK for the past 12 months, it's automatically satisfied. If not, then employers in the UK can potentially certify maintenance, or the worker may need to provide evidence that they have access to a certain level of maintenance to cover themselves and potentially their family members. As with all immigration routes, there are also suitability requirements. These relate to conduct and character, and they could result in an application being refused if someone has any criminal convictions, if they've deceived the Home Office, relied on false documents, things like that. So that's where kind of we'd liaise with the visa applicant to kind of get a background about their history to see if there's going to be any problems from that side. 9 times out of 10, if they've already got that student visa, they've probably already satisfied the suitability requirements. So unless they've done kind of anything that kind of impacts their character since getting that student visa, that's probably going to be okay. Minimum salary rates, then you've all probably heard that these have been significantly revised earlier this year. They were amended on the 4th of April 2024. So for all new sponsorships, so for applications and COS, certificates of sponsorship that are assigned after the 4th of April 2024, all roles are subject to a minimum salary of £38,700 100, and then 100% of the going rate for that job. So if you have a look on appendix skilled occupations, you'll see that each different occupation has a different job, and each different job has a different going rate, and that is the going rate. When I refer to the going rate, it's the going rate for that specific job that you're sponsoring the worker to do. So that's the general kind of salary threshold. But this can be reduced. So it can be reduced if a student has a PhD in a subject relevant to the job, if they have a PhD in a STEM subject that's relevant to the job, if the job's on the immigration salary list. So like I mentioned, it's always useful to have a look on there. If the student is a new entrant, or if the worker would be sponsored to do a specific health or education occupation specified in immigration rules. What we'll be looking at in a lot more detail today is this new entrant rate, which is what I've highlighted on that slide. If you're sponsoring someone that can benefit from the new entrant rates, it means that that 38,700 general salary, the new entrant rate is really, really useful. So it means that we can benefit from this lower general salary threshold, and then the going rate for the job is also potentially reduced as well. So that's reduced by 30%, making kind of the going rate 70%, as opposed to the 100% that's needed if no one can benefit from any reductions. It's important to remember that if you're approached by a skilled worker that was sponsored prior to the 4th of April 2024, then different salary rates will apply altogether. I won't be considering them in detail, I'm afraid, but yeah, they are the salary rates. So the new entrant salary rate is useful for students who have completed their course of study in the UK, but there are also various different kind of options and individuals who can benefit from the new entrant salary rate. And it's useful because, it reduces that rate that you have to pay the migrant. So it would apply to anyone that's under the age of 26. If they've undertaken something that's called a recognised postdoctoral position, if it's a UK regulated profession and the individual would be working towards a professional qualification in that profession. So, for example, it could be a lawyer, so someone who is training to be a solicitor in the UK. That's a regulated profession, so they're working towards regulation and full kind of qualification as a solicitor, so potentially they'd be able to benefit from this new entrant rate. Those that kind of are working towards full registration or chartered status, so accountants perhaps, for example. But the new entrant rate, importantly, it also applies to students switching into the skilled worker route from inside the UK. The student must have permission as a student, or permission as a student that expired less than 2 years before we submit this skilled worker application. So it's really important to kind of get information about a worker's history, because they may not necessarily currently have student permission to remain. They may have student permission to remain that expired within the last 2 years, but potentially you can still benefit from these lower new entrant rates. They must have studied a degree, a PhD, or a specific qualification in the UK, and they must be within 3 months of completing that course, or have completed at least 12 months of a PhD. It's very confusing that these requirements are in immigration rules, because the requirements to actually submit a skilled worker application do require 24 months completion of a PhD, and a skilled worker to have completed, a student to have completed kind of the course that they're studying, or at least have a certificate of sponsorship to start once the course has completed. So although immigration rules may kind of specify one thing, it's important that kind of since these changes have come into force, there are kind of a lot of errors in the immigration rules. The Home Office are aware of them. I don't know when they're going to be updated. New entrant rate would also apply to a graduate switching. So If someone has completed their course in the UK and they've then got that graduate visa in the UK, they can potentially benefit from new entrant rates as well. The most important thing when considering these new entrant salary rates is that there is a 4-year maximum length of sponsorship at the new entrant rate. So you can't sponsor someone for 5 years, which is the route to settlement, paying them a salary at the new entrant rate, but you can potentially sponsor them for 4 years. So it's a significant period of time that employee would be working for you. This 4 years does include time spent as a graduate. So that just means that as an employer, there's quite a lot of benefits to kind of recruit a student who has just completed their course in the UK and are switching into the skilled worker route from being a student. They'd be exempt from something called the immigration skills charge as well. So you'd save potentially a significant amount of money, and then you can sponsor them for the full kind of 4-year period at that new entrant rate. I've included a few examples just because I appreciate it's really difficult to explain kind of the minimum salary rates very simply for you. But for example, if JMW held a sponsor license, they've identified Alan, who is a German student and who has recently completed a master's degree in the UK. JMW want to sponsor Alan as a human resources advisor under occupation code 3571. So that's a code that I know is already on table 1 of appendix skilled occupations. So I go to that appendix, and then this is the information that you're presented with. So you'll see that we've got a going rate, and then we've got these 90%, 80%, 70% going rate salaries. So we already know that if we're sponsoring a new entrant, that general salary threshold of 38,700 is reduced to 30,960. Alan's completed a master's degree, which is a recognised qualification in the UK. So we know that he's in the UK as an international student. He's completed a course very recently, so he'd be able to benefit from that new entrant rate, and he's switching into the skilled worker category from the student category. So he can benefit from 70% of the going rate, which if you look at the 70% column is 30,960 or £15.88 per hour. JMW can sponsor Alan at this rate for 4 years, and that's because he's switching from the student category into the skilled worker category. Another example, Fresh Fruit Limited, they hold a sponsor license and they've identified Jazz, an Iranian graduate who has a graduate visa. So we know that Jazz has studied in the UK, and they've then gone on to get that graduate visa, and they've held that for 1 year. Fresh Fruit would like to sponsor Jazz as a software engineer under occupation code 2134. So we then go to appendix skilled occupations and have a look at code 2134. And we know that because Jazz has the graduate visa, Jazz has already studied in the UK because they wouldn't have that graduate visa anyway. So we're looking at the new entrant rates again. So the general salary threshold is that reduced 30,960, and then we also benefit from the 70% of the going rate, which in this case is 34,580 or 17.73 per hour. Because that is higher than the general salary threshold, it is that 34,580 fee that we would have to pay. So we'd have to make sure that kind of Jazz's salary complies with that 17.73 per hour. Jazz already has a graduate visa for 1 year, so we can sponsor Jazz at this new entrant rate for 3 years to make the total 4 years overall. So we've identified these workers, but what do we need to enable us to sponsor them? We need something that's called a sponsor license. This enables kind of you to sponsor these workers, and by holding a sponsor license, you can issue what's called a certificate of sponsorship, or a COS, that the worker would use in their visa applications. Sponsor license holders will need to comply with various duties, and it's important to remember that sponsor licenses can be held for other categories of the immigration rules as well. So whilst I've only considered the skilled worker route today, there are potentially other routes that businesses can benefit from, in particular international businesses. Compliance duties then is kind of the main thing about kind of holding a sponsor license. The Home Office look at it as though it's sponsoring workers is a privilege, it's not a right, and sponsors must help the Home Office to kind of monitor their immigration system and to ensure that kind of the route is not abused. So as a sponsor, when you're applying for a sponsor license, you have to demonstrate that you can comply with these duties. So you have practices in place so that you know if a sponsored migrant doesn't turn up to work, you'd be able to report that to the Home Office. You'd be able to report any changes to your business. You'd be able to retain documents in relation to your sponsored worker and all your kind of your right to work checks that you do. They need to be satisfied by, having all these processes in place that you are complying with immigration laws. So you're only assigning certificates of sponsorship to those who can actually benefit from the skilled worker route, and that you're also complying with wider UK law, so employment law. You're paying the minimum wage to your workers, you're abiding by working time regulations and things like that. The Home Office must also be satisfied that you're not engaging in behaviour or actions that are not conducive to the public good. Now, there are quite a lot of benefits of holding a sponsor licence, and these are summarised on this slide. So, for example, holding a sponsor licence is really good for staff retention. The permission to remain that a skilled worker gets is dependent on that sponsored role that they're doing for you. So the likelihood is that that worker will continue to undertake that role with you because their visa is dependent on it. Obviously people get new jobs and new sponsorship, but the worker is more likely to stay in that role for a longer period of time. There's financial benefits as well. So, for example, kind of money spent training staff could be reduced if you're kind of retaining workers for a longer period of time. Equally, if you're sponsoring students who are switching into the skilled worker category, you can potentially save on sponsorship fees because you may be exempt from paying something that's called the immigration skills charge for sponsoring workers. There's a huge pool of talent to sponsor. So the UK attracts more than 480,000 international students each year. In the year ending September 2023, there were more than 104,000 graduate visas that were issued. These are all individuals that potentially are looking for sponsorship, so there's a lot to consider. It makes you an attractive employer, I think, and it also makes kind of your workforce diverse. This slide I've just summarised like the sponsor licence process, but essentially you have to demonstrate that you can be an approved sponsor so you can comply with the duties that I summarised on an earlier slide. You will have to identify key personnel, so people who will manage the sponsor licensing process, people who can access the sponsor management system on your behalf if the sponsor licence is issued. That can be a legal representative, but we always need to nominate people in-house, so within your organisation as well. You then gather the documents, so we'd send all the documents and information to the Home Office once we've submitted the online application form and paid the relevant fee. And then we'd wait for a decision. So decision times generally about 8 to 12 weeks. There are ways of prioritising a sponsor licence. I managed to get a priority service a couple of weeks ago, and we had an application that was decided within about 2 days. So it works. It's great. It sometimes is a little bit difficult to get hold of, but we can get it. So if you hold a sponsor licence, you've found an ideal candidate who can undertake a skilled occupation that's suitable for sponsorship, what are we going to do next? So obviously the first stage would always be to check that role is suitable for sponsorship and that the applicant would qualify for permission as a skilled worker. There's no point going down this process if they can't actually inevitably get a skilled worker visa, so it's always good to have that assessment at first. We then get a certificate of sponsorship on the sponsor licence that we can assign to the worker, and then once we've done that, we can proceed with the worker's visa application, which is generally an online application to the Home Office. So now Arsalan is going to take you through discrimination.
Thank you, Gemma. So some of you may be aware of KPMG's recent cancellation of job offers to some foreign graduates in the UK after the salary threshold was increased. But this move to revoke offers and restrict jobs to British citizens only inherently comes with risk and could potentially be seen as unlawful discrimination. So I will, in the next 15 minutes, provide a whistle-stop tour on the law around discrimination as it currently stands, which will cover the Equality Act, the protected characteristics, who the Equality Act covers, what the types of prohibited conduct are, as well as the consequences of discriminatory conduct, and how employers can minimize risk. I mean, discrimination in itself is quite a varied and broad topic. So this is just going to be really quite a brief introduction into it. So the Equality Act covers unlawful discrimination. Prior to this, discrimination law in the UK was quite varied. The Equality Act was brought into force to harmonise various different statutes and statutory instruments on discrimination law that were already in existence. It covers unlawful discrimination in the workplace and related fields, as well as relation to goods, facilities, services, education, transport, and certain public services. Discrimination is only lawful if it is connected to one of the characteristics that is protected in law. So I've provided a list below, which you could find in sections 5 to 12 of the Act. There are 9 in total, ranging from age to religion, belief, sexual orientation. Importantly, however, for the purposes of this webinar, I'll be focusing on race, which is the most relevant protected characteristic in an immigration context. So you will note, first of all, that being a visa national is not a protected characteristic. However, race is. Discrimination on the basis of immigration status will not amount to race discrimination on the basis of nationality. So the Supreme Court, in decision concerning this very issue, noted that Parliament could have chosen to include immigration status in the list of protected characteristics, but it did not do so. Nevertheless, immigration status is a function of nationality, and so care should always be taken by employers. So we'll see this later on. There is sort of been case law over the past couple of years where this has been tested, and the employment tribunal has found that employers have been discriminatory in their recruitment practices towards migrant workers because of their race and because of their sort of visa status. Race is defined in Section 9 of the Equality Act and includes colour, nationality, and ethnic or national origins. It is important to know, however, that the definition of race is non-exhaustive, meaning factors other than those listed here may be covered. So who is covered in the Equality Act? So importantly, actions that fall within the statutory definitions of discrimination are not necessarily unlawful. Rather, such actions to give rise to potential claims in an employment tribunal, they must be covered by Part 5 of the Equalities Act 2010, which covers discrimination in the workplace. So Part 5 protects a wide range of people within the field of work. That is much wider than one might expect. So it covers police officers and judges who are office holders, employees, of course, as well as surprisingly corporations. It doesn't cover volunteers, however, even if the nature of their work is no different than paid employees. Importantly, Section 39(1) states that it also covers job applicants. Section 39(1) states an employer A must not discriminate against a person B in the arrangements A makes by deciding to whom to offer employment, as to the terms on which A offers B employment, by not offering B employment. To add to this, Section 60A1 came to force recently. It was added on 1st of January 2024. And that stated a person A must not make a discriminatory statement in connection with a relevant decision that A makes or might make. A relevant decision for these purposes would be a decision about who to hire. Arrangements are not confined to those which employers make in deciding who should be offered a specific job, but is construed quite broadly and includes such things as advertisements for jobs, the application process and interview stage, as well as the format and content of application forms. Technically, therefore, someone who has not yet even applied for a job can theoretically bring the discrimination claim in respect of employers' recruitment arrangements. So, what is prohibited conduct? I'm not going to go through all of these. So you've got direct discrimination, indirect discrimination, harassment, victimization, and discrimination by association, perception. I'm just going to cover direct discrimination and indirect discrimination for the purposes of this webinar. So direct discrimination is defined under Section 13 of the Equality Act, and in broad terms protects people who are treated less favourably than others because of a protected characteristic. So this definition compromises of several elements, which include: 1, being treated less favourably; 2, the treatment is less favourable than that which would or has been given to others which do not share the protected characteristic. So importantly, the comparative exercise is the heart of discrimination here. So you're comparing someone that has that protected characteristic, who has been treated less favourably, to someone who does not have that protected characteristic. And then 3, the reason for the less favourable treatment is because of the protected characteristic. So it has to be because of the race. Examples of direct discrimination could include rejecting all job applicants because they do not have British nationality or another specified nationality, refusing to consider any non-British or Irish job applicants, not interviewing someone from a certain nationality or ethnic group because it is assumed that they will not have the right to work in the UK, and carrying out right to work checks for BAME employees but not for white colleagues. So indirect discrimination is a bit more nuanced and is referred to in Section 19 of the Equality Act. It arises where employers' decisions, practices or policies, which are also referred to as provisions, criteria or practice, or PCP for short, appear to treat all employees in the same way, but in fact disadvantage a particular group of employees with a particular characteristic. Where this happens, there will be unlawful indirect discrimination unless the employer is able to objectively justify the PCP. In this instance, it's important to note it does not make a difference whether anyone intended the policy to be disadvantageous, as long as there is some disadvantage and it is disproportionately affecting a certain group of people, it would be classed as indirect discrimination. So an example would be if an employer had a PCP to require that an employee has been resident in the UK for over 5 years prior to starting employment and is likely to be indirectly discriminatory, since some migrants who have the right to work will not have been resident in the UK for that period of time. So I'm just going to talk a bit about the case of Osborne Clark v. Purohit, which was a case decided in 2009. This is a good example as to how employers can be caught out by indirect discrimination claims. And it involves the old style work permit. However, the facts and the plan decision are still relevant to this day. So for those that do not know, Osborne Clark are a law firm. They advertised a position for training contracts. Purohit, who was an international student in the UK, applied for this role. As part of the application process, he was asked a number of questions, one of which inquired whether he held a work permit entitling him to work in the UK, to which he answered no. His application was rejected, and he was told that the firm did not accept applications from candidates that required a work permit because the firm wasn't able to obtain work permits for candidates to be able to take up employment in the UK. It's important to note in this particular instance, Osborne Clark did not reject the application based on merits, but rather had rejected it without any further consideration of his skills and qualifications for the role. On the back of this, Mr. Purohit brought a claim in the Employment Tribunal for indirect race discrimination, amongst other claims. The Employment Tribunal held that the firm's policy of automatically excluding non-EEA nationals from the pool of candidates for training contracts amounted to indirect race discrimination on the grounds of nationality. This decision was appealed by Osborne Clark. It was then heard in the Employment Appeals Tribunal. He also found that the policy could not be objectively justified on the basis of costs alone. So a cost-saving exercise in this instance was not enough to be an objective justification as to why they weren't taking on non-EEA applicants. Instead, the Employment Appeals Tribunal stated the firm should have conducted the recruitment process on merits as normal and should have only thought about sponsorship questions towards the end of the process. So this case clearly shows that an automatic rejection policy based on right to work status is likely to be indirectly race discriminatory. So who can be liable for discriminatory conduct? And it captures more people than you would consider initially. So of course, employers can be vicariously liable. For the purpose of the Equality Act, anything done by an employee in the course of their employment is treated as having also been done by the employer. And that is regardless of whether the employee's acts were done with the employer's knowledge or approval. Therefore, an employer can be vicariously liable for the discriminatory actions of its managers and other employees who have been involved in the recruitment exercise, even if those acts were contrary to the instructions that were given. Recruitment agents as employment service providers may also arguably be directly liable to an applicant or a potential applicant for discrimination, harassment or victimization, even if not acting on the employer's authority. And there is also personal liability for the actual perpetrator. So, for example, a hiring manager can themselves be individually liable for their actions under Section 1110 of the Equality Act. And so what are the consequences of discrimination? So the first and probably arguably one of the biggest consequences would be an employment tribunal claim being brought. So anyone who believes they have been discriminated against may issue a claim in an employment tribunal, which will result in a lengthy and expensive litigation and conclude with the tribunal ordering the employer to pay compensation for which there is no limit. I deal with a lot of employment discrimination claims all the time, and legal costs really do mount up. On top of that, as I said, there is no compensatory limit. So you have an injury feelings award, which could literally be in thousands or tens of thousands of pounds. In some instances, could be a couple of £100,000 from what I've seen. I think the highest compensation recently I've seen for a race discrimination claim was about £230,000. So it might mount up. On top of that, there's reputational damage as well. In a wider sense, being seen as a discriminatory employer would affect business reputation, which of course is an important distinguishing factor in a competitive marketplace for labour. Staff morale could be affected. Discrimination will affect staff churn rates, as a disengaged and unhappy employee will seek to work elsewhere. And ultimately, there's a net negative result, along with increased HR costs, reduced productivity, potential legal costs. The net negative result for workplace discrimination can be problematic for a business's bottom line. So how can an employer avoid discrimination? Well, there are quite a few different things that you can do. So carry out checks on all prospective employees. A lot of employers are caught out by right to work checks, which of course are a legal requirement. However, race discrimination is a risk when employers conduct right to work checks. To avoid claims for discrimination, employers should carry out appropriate checks on all prospective employees, and not merely those who appear to be of non-British descent. Do not prevent applicants from applying if they do not have the right to work. So with the EAT, and this is going back to Osborne Clark, held that employers should not prevent an individual from submitting an application for employment if they do not have the right to work in the UK at the date of the application. Said that should be the last consideration an employer should make. Following on from that, employers should focus on merits and ensure that job selections are made on the basis of suitability for the post. Employers should, as far as possible, base selection of candidates purely on merit and right to work issues, should only come into consideration at the last stage of selection. Employers should provide training to staff responsible for conducting right to work checks both before and during employment to ensure that it is done in a non-discriminatory way. Employers should also standardize right to work checks, ensuring that right to work checks are a standard part of the recruitment process, which is applicable to all candidates at the same stage, regardless of race. And as mentioned previously, right to work checks should be the final stage of any application process. Employers should not mandate how someone proves their right to work, and provide job applicants and employees every opportunity to enable them to prove their right to work to be in the UK and to undertake the work on offer. And job adverts. This is a big one. Ensure that job adverts, application forms and interview procedure do not discriminate against candidates. For instance, discouraging certain groups from applying. Job adverts should not include any wording that suggests the employer may directly discriminate by rejecting people with certain protected characteristics, i.e. by saying that only British applicants should apply or that they aren't hiring any non-UK applicants. And then finally, at an interview stage, should only ask candidates about their immigration status to determine whether the status limits the number of hours or type of work they may engage in, and not necessarily whether or not they have the right to work in the UK, or if that's going to be a hamper in the future. And I think that's everything. So yeah, any questions?
I think there is a lot around, and I think we've discussed these prior to the webinar. I think people are just looking for a clean yay or nay on some of the questions. So one of the questions was, most institutions have job fairs coming up in the next academic year, so that happens around October, November time. We do have a large proportion of employers who, for whatever reason, say they won't be sponsoring. Can they do that? Can they put a sign on the table saying they do not sponsor? Where do universities stand in that respect with employers?
They really shouldn't, and that was shown in that case of Osborne and Clark that we mentioned previously. The government has also provided a code of practice for employers on avoiding local discrimination. We can send that across actually out.
That'd be great.
Really helpful for employers. And really, employers should not be stating off the bat that they won't be accepting any applications from non-UK residents or any migrant workers, because that in itself is inherently indirect discrimination. If they were to be challenged by a job applicant, I mean, it could get quite difficult for the employer. So yeah, really, at the beginning stage, no, there shouldn't be anything to say. We're not going to be entertaining offers unless, of course, there are certain circumstances, for example, where the salary on offer doesn't meet the threshold for the skilled worker visa salary. In that instance, it would be impossible for them to actually sponsor a worker. But if the salary is meeting the requirement for the threshold, then no, it really shouldn't be.
Because I think that follows on from the next question. Is it acceptable to state in the job advert sponsorship will not be offered even if the salary threshold is met? And I think you've just clarified that that's not allowed. So I think that comes into another question that's come up in various different forms, which is at what stage should the employer be asking for the right to work? Because we're seeing it more and more in job adverts where they ask for it straight at the start, and a lot of students are feeling that they're being rejected. As soon as they tick no, they get that rejection email within minutes.
I know, which is exactly the situation in Osborne Clark, which the tribunal found to be discriminatory. Employers should be asking right to work questions right at the end of the application process. This is after looking at the merits of the applicants and the suitability for the post. Only then should they actually start considering right to work.
Thank you. And then another one is with that 4 years, if the employer is saying that they're not going to sponsor because in 4 years' time, they can't reach the next level of requirement, so the student moves out of the new entrant, is that allowed?
It's not for you, really.
Yeah.
I mean, from my point of view, like you can sponsor that worker for 4 years, can't you? So you can benefit from that worker for 4 years. And how do you know when you're going to sponsor that worker what salary they're going to be paid in 4 years? They might help you win a huge deal, and you may give them a pay rise that meets kind of the general salary threshold of 38.7. I guess from a discrimination point of view.
Yeah, I mean, it's the same. I mean, at that point in time, how can you make that decision as to whether or not you're going to be employing the person in 4 years or
long
it is, and I don't think that excuse in itself would be enough of sort of excuse for any tribunal judge if they were to come across that.
Right. And if a student, say, goes onto the new entrant route with one company, but then switches to a different company, does that new entrant stay with them for the full 4 years, or do they move up onto the experienced worker?
Yeah, so they can still benefit from that new entrant rate for 4 years. It's just that you have to bear in mind that if they switch into that graduate route first, that is included in that 4-year period.
Brilliant, thank you. And I think there was another question around so the 2 years, if they spent 2 years on the graduate visa, would the employer then support changing the visa skilled route for 2 years? So that graduate time spent on graduate route does count towards the 4 years.
Yeah, so kind of the benefit for employers really is that, sponsoring them direct out of education, you'd save money on the immigration skills charge, and you'd also be able to pay them at that lower rate for 4 years.
Thank you. And employers can't use cost of sponsorship as a reason not to sponsor.
It's not, no. It's not a good enough reason. Cost alone in itself is not a good enough reason. Yeah.
Because we're seeing some employers discourage students from engaging in the graduate route because they incur costs. If they switch into the skilled worker route, the employer incurs costs.
Yeah.
Yeah.
Okay. Moving on to some of the Q&As that were, I think you covered some of the cost, didn't you, Gemma, around the visas for employers. Do you know what the rejection rate is for students moving into the graduate route visa?
I don't know off the top of my head. I could have a Google it when the webinar's finished and see if I could find any, but I'd imagine very few graduate visas are refused. It's very straightforward. You have to have completed that qualification, and if you've completed a qualification that's recognised, as long as there's no suitability issues in terms of your character, it's reasonably straightforward.
Brilliant, thank you. And then how much does the graduate route cost for an international student?
Do you want to get the visa application fees up?
Yeah.
Is that what you want to know, visa application fee? So you'd have a visa application fee and then an immigration health surcharge as well. So the immigration health surcharge is at $1,035 a year. Graduate visa is $822.
Great. And if an employer says they don't have a sponsor license, is that a legitimate reason not to sponsor?
Yeah, I mean, yeah, if they don't have a sponsor license and they don't necessarily need a sponsor license or are actually going to get a sponsor license, then they can make the argument, of course, that it would be illegal for them to employ them, and so they can't really necessarily actually employ any non-UK citizen.
What if they were the most suitable candidate?
If they were, yeah, it's with discrimination claims, a lot of it is grey area. A lot of things haven't been tested or still need to be tested, and so I mean, if anyone wants to test it, I'm more than happy to help.
Right. Now, this next one is one that we see a lot, and actually a number of employers have actually got it on their recruitment websites, and we've been briefed by certain employers about this as higher education institutions, where because a lot of them run training or graduate programs or graduate schemes that may be more than 2 years, they're rejecting students or saying they do not hire students via the graduate route visa because that only allows them to stay for 2 years, and the actual role is longer than 2 years. And then they say that because they would need to sponsor them to move to remain for the entire program or graduate scheme or contract that they have, that they're not in a position to do that because of the salary. So the student is being rejected now based on a potential salary. As we know, the government might change and things might happen, that they potentially have to meet in 2 years' time.
Yeah, but once again, I don't necessarily think that's a good enough excuse for an employer to reject a candidate now based on what might happen or might not happen in 2 years' time. Really, they should be looking at sort of now and what's happening at the moment. Of course, they need a job plan for the future, of course. But if that stops them from recruiting, the most suitable person, it's only going to affect them. It's only going to affect the business negatively.
Yeah.
Overall.
Because we want to have these confident conversations with employers. We want to support them and prevent potential discrimination. But we are finding employers increasingly stating that they won't hire students on the graduate route for graduate programs or graduate schemes that are longer than 2 years because they can't stay, but then won't consider the skilled sponsor, the skilled worker route.
As well. Can you imagine if the worker had status as a spouse or something like that? So they had a visa for 2.5 years, it would still be less than the 3 years. So would they reject in them circumstances as well? So it's an interesting one, isn't it?
I think employers also just need to approach it in a different way.
Yeah.
Consider if it was somebody else that had a different protected characteristic, for example, if it was a disabled person and on their application form they said, if you have a disability, you cannot apply. I mean, off the pattern itself will cause quite an uproar. So I don't see why employers feel like they can do the same for the protected characteristic for race.
Yeah. So as higher education institutions, and we have our job boards that we have, and employers do submit vacancies to us. What do you advise when they say you need to have the right to work in the UK as part of the application process? Is there particular wording we should be looking out for? Is there particular advice we should give to an employer? And also, at what stage should they be asking that question? Yeah,
it should be asked right at the end. So once the application process is pretty much finalised and they've come to a short list of people that are most suitable for the role based on their merits, only then should they ask the question of right to work. And then, I mean, they can ask it sort of as it is, whether or not they do have the right to work in the UK. But just because they don't have the right to work in the UK at this moment in time, there's not a reason to reject them, because they can sponsor them, or they may get a visa in some sort of other way as a spouse or a dependent of a skilled worker or another way. So it should really be asked right at the end.
And just to touch on placements and internships, I know we've had this discussion before, but employers saying that they don't accept international students onto placements or internships because they don't sponsor at graduate level. What should we be advising employers?
That's a good question. So
students who have completed their course?
So basically students who are currently studying, who can do their placement or internship on their student visa, so no requirement for the employer to sponsor. It's assessed part of their program. The employers are refusing to hire students, international students, onto these because they use it as a recruitment channel at graduate level, and they feel that if they don't recruit at graduate level international students, then potentially international students are taking the place of home students on these programs.
I don't think they're publicised very much. I don't think employers understand how a work placement works. It is fairly straightforward. Sometimes it's you need specific documents for the right to work purposes that the student is kind of doing a work placement as part of the course. But as long as the university is able to provide that, it is fairly straightforward. And I was working with an employer recently, and like I said earlier, they were studying an engineering management degree, and they could do the management aspect as part of a work placement, and it was at a retail organisation, so it's completely nothing to do with engineering. So it's definitely something to consider for students. Like if you're approached, kind of the case that I was dealing with, the student approached kind of their existing employer about it. They hadn't offered one before. They realised, that the process was fairly straightforward, and they decided to offer the work placement. But yeah, they can't publicise very much. Like employers don't know a lot about work placements in my experience.
Yeah, and we have worked with some who have placement programs embedded in the organisation, but again, they're using the fact that they don't sponsor at graduate level as a reason not to hire at placement level, even though there's no visa requirements on behalf of the employer. And the placement is not a prerequisite of getting onto the graduate. You don't have to do the placement to qualify.
It's part of the student visa, so yeah.
Brilliant. We have so many questions, and I know that we're coming to the end now. So yeah, I think for us, last thoughts really, as higher education staff or as employers who are joining us on the call as well, what can we do going forward to make sure, your last thought, last tip, to make sure that we are mitigating discriminatory behaviour, adverts, etc. going forward, or advocating best for our international students?
For employers, just focus on the merits and suitability for the post of job applicants. Don't consider right to work checks at the beginning. You're going to be potentially negatively affecting the business in the long run in a whole host of ways. So yeah, always hire, I guess, the person that's most suitable regardless of their nationality or their visa status.
Yeah, and be prepared. Like, there's a huge pool of talent of students international students in the UK, so get that sponsor license. You might not have someone that you want to sponsor at the minute, but getting it in place means that you're in a position to sponsor. We've
helped quite a few companies to get sponsor licenses, and it opens up so much the actual, just the skills and the different ways of thinking, people from different parts of the world bring in to their organizations. So yeah, definitely worth sort of going down the route.
Thank you both. Thank you so much for your time today. Thank you everyone for joining us for the session. It has been recorded. We will share the recording and the slides. But yeah, thank you so much for everything that that you've shared with us today. It's great to get these insights. I know that there's so many more questions coming in, but if you want to contact Gemma and Arsalan and ask those questions, they're providing the 30-minute free consultation. So this information will be in the slides.
Thank you so much.